From the 26th of October this year, businesses are going to be under a new duty to take reasonable steps to prevent sexual harassment of their workers. I'm Huw Cooke from the employment team at Burgess Salmon, and these are the 5 things that I think you need to know about this new sexual harassment duty. My first point to get your attention is about what happens if you get it wrong. A failure to take reasonable steps doesn't give rise to a new standalone claim under the Equality Act, but if someone succeeds with a claim of sexual harassment, compensation can be increased by up to 25%, and as there's no cap on these claims, this uplift could be material. A failure to comply with the duty can also lead to investigation and enforcement action by the EHRC, the Equality and Human Rights Commission. The second point to consider is that the duty is proactive, preventative and ongoing. You need to anticipate scenarios where workers might be subject to unwanted conduct of a sexual nature in the course of their work and take preemptive steps to prevent such conduct. You shouldn't wait until there's been an incident to take action. My third point highlights the breadth of the duty. The EHRC's guidance specifically states that a business must take reasonable steps to prevent the harassment of its workers, not just by other staff, but also by third parties. In other words, you'll need to consider how to prevent harassment by clients, customers, service users, and members of the public. Moving on to the fourth point, you should start by carrying out a risk assessment to identify where in your business staff might be at risk of sexual harassment and the steps that you can take to reduce those risks. When carrying out your risk assessment, I'd recommend that as a minimum, you engage with key stakeholders, consider the composition of your workforce, review how your staff work and how the business operates on a day-to-day basis, carry out a physical assessment of the workplace, and review any past complaints. A good risk assessment will inform the extent of the risks and what to do next. It'll also act as a reference point for future review and demonstrate your compliance in the event of a claim or investigation. And finally, point 5, the big question. Having done your risk assessment, how do you decide what you're actually going to do? As you might expect, there's no checklist of reasonable steps that you can take to comply with the duty. What's reasonable is going to vary from employer to employer, and that's the whole point. You need to identify and take the steps that address the possible risks in your organisation. What I will say is that while training of staff and policies and procedures are going to be important steps, don't stop there. You might think about workplace signage, engagement with trade unions and employee bodies, ongoing employee communications, and an effective complaints handling process. The risk assessment will be key to help you identify what steps to take. Now, complying with the new duty is not a one-off process. Just because we're all talking about it now doesn't mean that you can take steps and forget about it. It's an ongoing duty requiring regular monitoring, review and reassessment so that you can respond as and when things change. If you'd like to talk to us about what you should be doing to comply with the new duty to prevent sexual harassment in the workplace or any other employment law or business immigration matters, please do get in touch.